Hi, good afternoon. Thank you for having me today. Thank you to Pastors Mac and Lynn for inviting me. I understand you guys have been dancing today. This is not going to be that kind of session. I also want to thank just the Living Word family for the tremendous support that they have been to me and to my team of lawyers over the years. Kay Spakowski, who is one of my dear sisters in Christ, has formed countless teams of intercessors to help pray us through some really dicey legal and political situations. And Gary Essig has volunteered to become my personal bodyguard when I go and testify, which is a huge blessing. And you've got people like Pastor Terrence here who are like Jesus with skin on. So this is just a blessing to be here. So thank you so much. I was reflecting the other day on the role of the law. And in the Old Testament, God's law was a standard of conduct that exposed sin, the sin of the people. But today, man's law doesn't necessarily play that role. And in fact, in some cases, it not only condones, but it actually mandates sin. So what am I talking about? Some examples: forcing nurses to perform abortions, or business owners to pay for them, forcing doctors to perform sex change surgeries, or taxpayers to pay for them, forcing creative professionals to use their God-given talents to beautify and celebrate same-sex marriages with which they disagree, forcing girls to undress and shower and use the bathroom in front of biological boys at school. These are some of the very few examples, but there's a lot more. For the last 18 years, I've practiced primarily in business law, but in the last 5 years, my practice started to shift to helping churches and Christian-owned businesses and ministries and Christian schools navigate the rough waters of living out their faith in a generation that, frankly, has passed a lot of ungodly laws. And a lot of people have asked me, well, why do you do this? And I answer them, it's because of them. God has blessed me with a tremendous family and a loving husband of nearly 20 years, 5 children from 7 to 17 who are all saved and genuinely love the Lord. Now, not all kids get to be raised by their biological parents like my kids do. Not all kids get to even be raised by a mom and a dad. But while there's brokenness, we need to remember that this is God's ideal, the family. Okay? And for several decades, the family has been taking a beating in no small part because of the ungodly laws that have been passed. So it's my job to advocate for godly laws that promote life, marriage, family, godly sexuality, and God's creative design for distinct males and females, not the 58 other gender identities that are currently being officially recognized. 60 total. So we're going to briefly discuss some of the hottest legal topics for Christian businesses and for churches and ministries, and then we're going to end with some hot topics for students and parents of school-age kids. So we've got a lot to cover, so please listen fast. So we're going to dive right in with hot topics for Christian-owned businesses, and we're going to discuss 3 main things. First of all, life, and specifically who the government can force to pay to end life, conscience, especially in the post-Obergefell, which is the same-sex marriage decision, legal climate, and finally, gender and safety and privacy in the workplace. So we're going to dive right in and start with life. Many of you know that Hobby Lobby was a huge win for us at the United States Supreme Court a couple years ago. Hobby Lobby was facing fines of over $2 million a day for non-compliance with the Obamacare mandate that employers had to include abortion-inducing drugs in their employee health care plans. Okay? As a company that is committed to honoring the Lord and operating consistent with biblical principles, though, they felt that they had no choice but to sue the federal government, sue the Obama administration because they felt that the government was violating their First Amendment right to freely exercise their religion. And thankfully, in June of 2014, the United States Supreme Court agreed. Now, at the time, Hobby Lobby was a $3 billion company with about 55,000 employees. So size was not relevant in this ruling. In other words, you can be a big company and still retain your First Amendment rights to exercise religion. What was significant about this decision was that Hobby Lobby was able to demonstrate that they had genuinely held religious beliefs. They showed the Supreme Court that they had consistently operated their business according to their Christian faith. They publicly stated their mission to operate in accordance with their Christian faith. They had their leaders sign a statement of faith. They closed on Sundays, even though they were making $50 million as a craft company on Sundays. Again, showing that they put their faith above their bottom line. They did things like they offered Christian financial management classes, Christian dispute resolution classes, optional Bible studies. They self-imposed a minimum wage company-wide of $14 an hour. There's one down the street now if anybody needs to go apply. So what we learned from Hobby Lobby and from other cases like it is that when it comes to Christian character, you have to either use it or you lose it. Okay? So it would have been far more challenging for a business who has no appearance or record of expressing their faith to challenge this Obamacare mandate. You can't really claim that the government is violating your religious beliefs if you've never expressed those beliefs in how you operate your business. So that's important. Let's move on. Conscience. Okay, so about a year after Hobby Lobby was decided, 5 of the 9 Supreme Court justices overturned every relevant precedent and imposed same-sex marriage on all 50 states, finding that there was a constitutional right to same-sex marriage. Now, keep in mind that the Constitution clearly says that any power not specifically given by it to the federal government is reserved for the states. But, that's called federalism. But even though same-sex marriage is not found in the Constitution, these 5 justices saw fit to take away the right of the states to decide and basically summarily force same-sex marriage across the union. Now remember, these judges are unelected, which is why they should not be legislating. What happened after Obergefell is that the Supreme Court basically drew a line in the sand. And now many business owners, professionals, judges, clerks, people of all walks of life are having to make a decision. Are we going to obey God, or are we going to obey man? I think that some of the dissenting justices' statements are significant, so I'm just going to read a few of them. Chief Justice Roberts in that case said, "Today's decision creates serious questions about religious liberty. Many good and decent people oppose same-sex marriage as a tenet of faith, and their freedom to exercise religion is actually spelled out in the Constitution as opposed to the right that's been imagined by the majority, i.e. same-sex marriage." He goes on to say that the majority graciously suggests that religious believers continue to advocate and teach their views on marriage. But the First Amendment guarantees the freedom to exercise religion. Ominously, that is not a word that the majority uses. Now, why is this significant? If you tune into the presidential candidate debates, you'll notice that Hillary Clinton has now taken to referring to the First Amendment right to free exercise of religion as merely a right to worship. Now be wise and know that this choice of words is very intentional. Because if Americans only have the right to worship, then that right can reasonably be confined to 1 hour a week and within the 4 walls of the church. Okay? But in contrast, what the First Amendment really protects and guarantees is the right to freely exercise our faith. Okay? In our public lives, in our professional lives, in our schools, in our workplaces. There is no such doctrine as separation of church and state. It's just not in the Constitution, okay? And I think you probably all know that the historical, clear intent of the First Amendment was and is to keep the state out of the church's business, not vice versa. I think Justice Alito's dissent is very sobering. He says, "I assume that those who cling to old beliefs will be able to whisper their thoughts in the recesses of their homes. But if they repeat those views in public, they're going to risk being labeled as bigots and treated as such by governments, employers, and schools." Now keep in mind, this decision is only 1 year old, and already we're seeing just that. Non-discrimination laws are the primary weapon that is being used to enforce this ungodly ideology. There are three types of discrimination laws: employment, housing, and public accommodations. Public accommodations are just basically any company that's open to the public. So these laws make it illegal to discriminate against a person because of their membership in a protected class. A little background: these laws were created post-Civil War in a race-segregated United States. They were designed to ensure that Black Americans had access to essential public services. They originally prohibited discrimination against protected classes of race, religion, color, and national origin in essential services, but of course these laws have expanded through the years. Many people have attempted, and some successfully, to include gender identity and sexual orientation as protected classes. Now, there's been a lot of attempt year after year to do this at the federal level, which has thankfully to date failed. But if you were to go to like the Human Rights Commission website, you would read this statement. The Human Rights Campaign, along with tens of thousands of advocates, work around the clock to lobby members of Congress on critical legislation that would greatly affect the lives of lesbian, gay, bisexual, and transgender Americans. So these guys are getting hammered every single day. We need to pray for Congress. State laws, states are able to enact their non-discrimination laws as broadly as they want, so they can have as many protected classes as they want. They just aren't supposed to enforce them in such a way that it violates our First Amendment rights. Of course, that's exactly what's happening. About 50% of the states have included sexual orientation and gender identity protected classes in their non-discrimination laws. I'm going to refer to SOGI, sexual orientation, gender identity, because it's just way less syllables. So if you hear me say SOGI, then you know I'm talking about sexual orientation, gender identity. Minnesota is one of the states. We do have sexual orientation and gender identity as protected classes in this state. And we're going to talk about what that means in a minute. And then there's also local municipal ordinances that are popping up, also including these in their protected classes, along with some other things like sexual or gender expression. And there's lots of things that we don't quite know how to define yet. So let's talk about the impact of violating a SOGI law. It can carry tens of thousands of dollars of penalties if you're caught violating a SOGI law. And violating it just means that you are found to be treating that person in that protected class different, okay? So in New Mexico, for example, a wedding photographer by the name of Elaine Huguenon was forced to pay nearly $7,000 for declining to photograph a same-sex ceremony. In upstate New York, Robert and Cynthia Gifford were fined $13,000 for refusing to host a same-sex marriage in their farm and farmhouse where they live. It's their house. In Oregon, the Kleins, Aaron and Mellissa Klein, were recently ordered to pay $135,000 to a same-sex couple because they declined to bake a wedding cake celebrating their wedding because it violated their sincerely held religious beliefs. The lesbian couple in that case claimed that the Kleins had emotionally raped them. And so that's how we got to $135,000. That case is obviously being appealed. There's also some non-monetary damages that we're seeing. For example, there's a cake baker in Colorado by the name of Jack Phillips who was ordered to undergo re-education by the courts to fix his beliefs about marriage. And he has to file quarterly reports with the government showing that he's now compliant with the non-discrimination law, again, because he declined to bake a cake. Some SOGI laws even include criminal penalties. So Donald and Evelyn Knapp right now are facing 6 months in prison for refusing as ordained ministers to perform same-sex ceremonies at the wedding chapel that they own. So we can see that this is, the SOGI laws are very dangerous things for people of faith. Some of you are wiping the sweat off of your foreheads right now and thanking God that he did not call you into an industry that directly serves marriages and weddings. But keep in mind that the issues keep expanding. So we're seeing them all across the board in every industry. Doctors' licenses are being threatened if they don't want to artificially inseminate lesbian mothers. Counselors are being targeted if they want to counsel people according to their Christian faith. Maybe you have an employee who marries their same-sex partner, now you're paying for spousal benefits. The list goes on, and it continues to expand daily. But even if you're never touched directly by the Obergefell decision, as followers of Jesus Christ, we must ask ourselves, what are my core business values? The beliefs and values that inform the decisions that I make. We are seeing more and more businesses are taking a direct role in the legal and political realm. So Starbucks CEO, for example, was very clear in his intent to create values and change culture. Here's a Starbucks statement expressing the values it spends its resources to promote. In contrast, look at how this coffee company used its resources. Mr. Cathy has been very clear about his company's mission. And so has Hobby Lobby. You see, we must all be prepared to give an account for the resources and the influence that the Lord has graciously given us. So I'm going to refer you to the handouts that are on the table right outside the door to give you practical legal information about how you can integrate your faith in your business and how you can make yourself an unattractive legal target to activists. So I don't have time to go into all that today because we're trying to do an overview, but please do pick up those resources when you leave. We are going to hit our last hot legal topic for business people, and that involves safety and privacy in the bathroom context. So there's kind of two questions in this field. First is, can companies legally protect their employees and customers' safety and privacy in bathrooms? And the next part of that question is, must they do so? Earlier this year, the EEOC, the Equal Employment Opportunity Commission, a government agency, they charged Minnesota-based Deluxe Corporation with discriminating against a transgender employee because Deluxe had a policy that employees must use the bathrooms that correlate with their biological sex. This was the third company that the EEOC targeted for this reason, and they are pledging to make this a major priority for their agency. Now, to be clear, Title VII, which is the non-discrimination law that employers must follow, does not recognize gender identity as a protected class. But the Obama administration has decided that Title VII's ban on sex discrimination, which of course was intended to ensure that women were treated fairly in the workplace, now includes gender identity. So, in other words, the president summarily redefined the term sex in federal law to include gender identity. Okay? Now, for those astute people who remember back in second grade learning about the three branches of government, you will recall that the executive branch of government does not have the power to legislate. And that is exactly the battle that is being waged right now in federal courts against the Obama administration. So, can employers maintain sex-segregated bathrooms? The EEOC would say no, but we'll learn in a bit that there is a national injunction on the president's attempt to legislate an expansion of the term sex. It's temporary, but it's in place right now. The next question is, must businesses protect privacy and safety? We all know about Target, and maybe you do or don't know, but the YMCA is doing the same thing. So this is still unknown. Minnesota is one of several states that recognizes a tort called invasion of privacy. Now, a Google search is going to really quickly reveal all of the instances of voyeurism in Target bathrooms and changing areas that have taken place since their big announcements that they were going to open up bathrooms and changing areas to any gender. There haven't been any cases on this to test it yet, but I imagine that the first victim of sexual assault in a Target bathroom is probably going to name Target as a defendant. okay? Because, for not taking measures to protect them in intimate spaces. These businesses have a duty to keep ice off of their sidewalks to protect their customers. So it's not too difficult to imagine that a court would find that they have a duty to take reasonable steps to keep men out of the women's bathroom, especially sexual predators posing as transgender and pedophiles. If you're not boycotting Target, I just want you to know that about 1.5 million people are taking a stand for their faith with their money, and this has resulted in a 7% loss of revenue and an 18-point drop in their stock since they announced this. Now, they haven't budged on their position, but boycotters believe that a sustained boycott will force their hand. And other big companies are watching. They're not really excited about taking those kind of financial hits. So we are going to switch gears now and keep moving and start talking about hot legal topics for churches and for ministries. So we already discussed that public accommodations are required to comply with non-discrimination laws. And again, 50% of states have SOGI protected classes, okay? So you can imagine how dangerous it is that churches in some states are losing their freedom to exercise religion. And if you think I'm being dramatic, a court in Iowa recently said that if the church opens its services up to the public, do you know any churches that don't open their services up to the public? Then it should be treated as a public accommodation, and then it is subject to that state's and city's non-discrimination laws. Yikes, right? Massachusetts is following suit. They're saying that if a church holds such secular events as like a spaghetti dinner that's open to the public, then it too should be treated as a public accommodation and charged with violating the local non-discrimination laws. If churches are treated as public accommodations subject to non-discrimination laws, it's going to have a major impact on so many different areas. A few of them are who the church must hire and cannot fire, who the church must allow to use their facilities, who the church must accept as members, who must be allowed to participate in ministry activities. For example, marriage retreats would not be able to be limited to heterosexual marriages. What weddings and other events, church ministries like catering department, the church band, etc., must serve, bathroom use, on and on and on and on. Now, just like in the business world, if your church or your ministry intends to continue to operate consistent with biblical values on life, marriage, and sexuality, and physical safety and privacy, it's extremely important that you put protections in place now. Hoping you don't get sued is never a good legal strategy. Trust me. You want to make your business or your church or your ministry an unattractive legal target. Okay? You want to bolster your legal position, and you want to increase the likelihood that any lawsuit that is launched against you, you can get rid of it on summary judgment at the beginning before tens of thousands of dollars are wasted defending yourself in a long trial and your name has been dragged through the mud in media. I just want to say this. The other team is on a mission, and they want to push us into adversarial mode, right? But we must never lose sight of the fact that homosexual people need Jesus more than they need to be heterosexual. A lot of heterosexual people are going to hell, okay? They need Jesus, and then the Holy Spirit's going to work on their heart. That said, we are to be wise as serpents and gentle as doves. Putting legal protections in place is not anti-LGBT. It is actually wise to legally protect your organization from militant activists and the people that you serve, your employees, your church members, the kids in your ministry. And again, I'm going to refer you to the handout. Oops, I think I forgot to do that. So I think we already said that. I'm going to refer you to your handout, though, to look at some of the recommended steps to take to put those protections in place. And there's probably going to be a lot more protections that you can put in place depending on what your church or ministry is called to do. We're going to end with hot legal topics for students and parents of public school children. And again, high-level overview. But as you know, Minnesota passed a bullying law that made just about everyone and their grandmother protected class. So, of course, it includes the SOGI protected classes as well. Now, this is bad law for so many, many reasons that I don't have time to discuss, but I will just say I was not surprised to find that the little kindergarten transgender kid in St. Paul last year invoked the bullying statute against his 5-year-old classmate who simply verbalized her observation that you're not a boy, or you're not a girl, you're a boy. Bullying. Athletics. Of course, you probably remember that in December of 2014, the Minnesota State High School League forced a policy to allow high school boys, forced a policy that required schools to allow high school boys to play on the girls' teams. Now, importantly, they do not need to have undergone any hormone therapy or surgeries. They don't need to have suppressed their testosterone. So these are fully loaded high school boys, okay? Now girls are being forced to compete against young men for a spot on the team, as well as to assume the risk of increased injury in competitive play against high school young men. Now, statistically, high school boys are 5 to 5.5 inches taller than girls, 20 to 40 pounds heavier. They have 150% the body weight, muscle mass, and skeletal mass as girls do. They have bigger hands, pelvises, and feet. They have more fast twitch muscle fibers. And we have decades of state, national, and Olympic statistics that just prove that young men run faster, jump higher, hit harder, et cetera, right? Anybody that watches sports knows this. And yet earlier this year, an Alaska girl who was running in her state track championship meet was bumped from medaling because there was a biological boy who identified as a girl who was allowed to run in the state track meet, and he medaled, and so she got bumped. Now, for those people who think that there's a religious school exemption in Minnesota, think again. It's paper thin, and it's not likely to hold water. Okay, the last hot legal topic for schools, or for students, is in May of this year, President Obama sent a letter to all schools across the nation saying that their federal funding was going to be cut if they didn't stop discriminating against transgender people by not allowing them to use the private facilities of their chosen gender. Now, this includes most private colleges. Title IX prohibits discrimination on the basis of sex, like Title VII, and of course this was, again, enacted to stop systemic discrimination against women and girls in education and athletics. But again, President Obama redefined the term sex to include gender identity in this law as well. Many people think that this letter President Obama mandates just a change to bathroom policies, but in fact, it is much broader than that. It includes locker rooms, showers, sports, overnight trips for out-of-town games, and even dorm rooms. So you can imagine your little girl going off to college and finding out that her roommate is a biological male. Now, what's interesting is that the same law that President Obama is using as a weapon against women and girls, which was designed, of course, to protect us, also says these things. It says schools can maintain separate living facilities for the different sexes. Schools can provide separate toilets and locker rooms and shower facilities on the basis of sex. It repeatedly references one sex and the other sex. But Title IX funding is no small threat to withhold. $68 billion is distributed by the Department of Education every year, averaging about $1,200 per student. And so you can imagine this is scary for school districts who are now running to make policies to comply with the president's mandate, you know, even though it puts girls at risk. Now, what's interesting is that for many, many decades, the federal courts have recognized a right to privacy of one's unclothed figure. The Ninth Circuit said shielding one's unclothed figure from the view of strangers, particularly strangers of the opposite sex, is impelled by elementary self-respect and personal dignity. There is also a constitutionally protected privacy interest in one's partially clothed body, another court said. Now, can anyone guess the context where the right of privacy of one's unclothed body was established? Any takers? What these cases might be talking about? These cases established the right of prisoners to undress and use the bathroom out of the view of female guards. Now, if prisoners have this right, shouldn't our little girls have the same right when they change for gym class, or shower after a sporting practice, or sleep in a hotel bed for an out-of-town tournament? There are now 24 states that are suing the Obama administration over this new policy to fight for this very right. We filed a lawsuit a couple weeks ago in federal court here in Minnesota, arising out of a policy like this in Virginia, Minnesota, that has resulted in a boy who identifies as a girl sexually harassing the girls in the locker room. He likes to go into the locker room, pull up his skirt, and grind at the girls to erotic music. So we're suing. Here's the good news. There's some good news. Okay, the good news is that on August 21st of this year, a Texas federal district court judge imposed a national injunction on the Obama administration's expansion of the term sex to include gender identity. Okay, so this is going to affect employment, it's going to affect schools. Yes, but this injunction, of course, is temporary, okay? It's going to be appealed, but it is a small victory for now. What about private schools? Private schools should, in theory, have more protections than public schools, but we are seeing a disturbing trend there. In California, a recently proposed law would require all religious schools, unless you're like a seminary that exclusively trains ministers, to adopt SOGI non-discrimination laws. Now, thankfully, the author of that bill withdrew it a few weeks ago, but there was also a case in California where a plaintiff was demanding that her Christian school be treated as a public accommodation because they did such secular things as sell tickets to sporting events and sell concessions at their sporting events. So again, you know, this is where we're at. Now again, there's lots of things that Christian schools and even public schools can and should do to protect themselves from lawsuits. And again, I'm going to refer you to the materials outside. Now here's the big picture. The weapon that's being used to demand conformity with these ideologies right now is non-discrimination laws. The method that the other team is using is to target the unprepared. And the end game goal is to normalize these ideals and to silence opposition. They started with culture, moved quickly to Christian businesses and Christian schools and ministries, but the end game is ultimately to silence the church. But you can protect those behind you by taking a stand. Likewise, failing to take a stand will also impact those behind you. So what can you do? First and foremost, tell your story. Jesus loved to tell stories, right? But guess what? The other team is using stories to aggressively advance these ungodly laws. If you were to take out your cell phones right now and Google Gavin Grimm, G-R-I-M-M, you would find these pictures, and I can't even count how many stories there are of this young lady who, born a biological girl, felt that she was born into the wrong body, suffered terrible discrimination, and is now transitioning to be a male. Stories are powerful. Storytelling is powerful. I testified at the Minnesota legislature last spring on a bathroom bill, and I brought several of my young adult students with me. And we debriefed over lunch after the hearing. And I said to them, so in the court of public opinion, who won that debate? And their response was very telling. They said, if we didn't know better, the other side would have won, because their stories invoked compassion. They were compelling, and for that reason, they were persuasive. We have been called to steward the garden. Well, this includes the garden of ideas that create culture. So let's be thought leaders. Let's celebrate God's design for life, marriage, and sexuality. Our most persuasive argument is our life story, our godly marriage, our saved children. When we live our faith on our sleeves in our workplaces and schools, we're telling our story. Better yet, we're telling God's story. So I'm going to end with this. At the resource table, you're going to find lots of different things for you. And I would just encourage you to look closely at them. You're going to find practical legal information for Christian business owners, an employer's guide to faith in the workplace, practical legal information for your church and ministry and Christian school. We also have materials for public school children and parents from K through 12, as well as at the university level. And you'll find a flyer with my firm's information on it. You'll also find a flyer with Alliance Defending Freedom information on it, who they are. And basically, Alliance Defending Freedom is an international now organization composed of, we have now 3,000 Christian attorneys as part of our alliance, and we fight for these things internationally. And North Star Law and Policy Center is a Minnesota-based organization that several colleagues and I started a few years back, and they're Christian attorneys who all volunteer their time to advocate for these things. And so if you know any Christian attorneys, please grab one of these and give it to them. And finally, Minnesota Family Council, which is our state's family policy council. They fight every day for godly laws at the Capitol. And if you go to mfc.org, Minnesota Family Council, mfc.org, you can subscribe to their weekly email blast. It is an excellent way to stay informed, and they give you quick, easy ways to engage. Sometimes they take 1 to 3 minutes. And if you're not from Minnesota, find out who your policy council is in your state, and I'm sure they'll have something similar. So, I just want to encourage you. I always see the same faces after I'm done talking to people. People are like, oh, this is horrible. It's exciting. We're in exciting times to be Christians, right? We have African friends who tell us that American Christians are fat. And by that, they mean that we have some of the best teaching and preaching in the world. We have churches like Living Word Christian Center, okay? But we consume, but how much do we exercise our faith? The principle of just lifting weights. If you're just going to bench the bar, you're not going to gain a lot of muscle. But if you put a lot of weight on that counter pressure, when we resist that counter pressure and push back, we gain a lot of muscle. So this is an awesome time for us as Christians to live freely and to tell our story and to be bold for the Lord in our spheres of influence. So with that, I just want to say thank you for your time. Thank you for listening fast. If you have any questions, because we're running late today, please just feel free to come up to me afterwards. I'm going to hang out for a little bit. And the materials are out there as well, and my business card is out there if you want to reach out to me that way as well. So thank you for your time. You're dismissed for lunch.